Assalamualaikum warahmatullahi wabarakatuh. My name is Ni Amalia Aimi binti Ni Adnan. My matrix number 056807. I will talk about facts, issues and judgment of this case. Article 38 of the International Court of Justice Statutes refers to treaties and conventions in effect, logically barring treaties that have not yet entered into force and have stopped to be binding on the parties. The most common approach for a state to become bound by the commitments included in a treaty is to become a party to it. It has been claimed that when the treaty is a multinational convention of the lawmaking kind, a state might simply by behavior signal its adoption on the convention system as applicable to itself. The facts in this case is in 1933, an agreement has been signed between the Anglo-Iranian oil company with Iranian government. The agreement was approved by the Iranian Majlis on May 28, 1933 and went into effect the next day after receiving imperial assent. Before the agreement, in 1932, the Iranian government has signed and approved the Declaration of Obligatory Jurisdiction for the International Court of Justice. Since 1932, there have been no treaties between the United Kingdom and Iran that were relevant to the issue. According to the Iranian government, the Declaration of Obligatory Jurisdiction solely applies to treaties made after the declaration's ratifications, and hence the ICJ does not provide jurisdiction over this case. Since the statement, the United Kingdom believes the Anglo-Iranian oil company has not been managed in line with the principles and practices of treaties agreed with Turkey and other countries. The United Kingdom also argued that there have been a double charter in the contract which has been signed between the Anglo-Iranian oil company and Iran in 1933, and so that counted as a treaty or convention. The Iranian government further enacted several of the regulations that effectively nationalized Iran's oil industry on March 15 and 20, 1951. They also enacted another bill concerning the nationalization of the oil industry across the country. The imperial assent was granted for these two statutes on May 1, 1951. Because of this existence of legislation, a dispute has occurred between the Anglo-Iranian oil company and the Iranian government. The rights of this British company, which is the Anglo-Iranian Oil Company, has been fought by the government of United Kingdom and further decided to file an application to the court on the issue of invoking the diplomatic protection rights, also instituting proceedings in the name of the government of the United Kingdom and Northern Ireland against the imperial government of Iranian government. The issue in this case is first whether International Court of Justice has a jurisdiction over the disputes. Second, whether the settlement of disputes in 1933 between the government of Iran and the government of the United Kingdom relating to the DRQ Convention can be considered as a treaty or convention within the meaning in Iranian declaration. Third, whether the reason of the participation of the United Kingdom regarding this matter would be accepted. In this case, the court held that it cannot be accepted the view of the contract signed between the Iranian government and the Anglo-Persian oil company has a double character, where it can be concluded that it is nothing more than a concessionary contract between a government and a foreign corporation. The United Kingdom were not a party in the contract. It was just a country that the company living in. Thus, there is no privity of the contract between the government of Iran and the government of the United Kingdom. Under the deal, the Iranian government neither demand anything from the company nor can it be called upon to execute any commitments owed to the United Kingdom government that it owes to the company. It was also held that United Kingdom was not entitled to the treaties that concluded in 1933 with Iran. The dispute brought before the agreement by the United Kingdom was not one of those days arising with regards to the facts or situations that relate to the application of the conventions or treaties which accepted by Persia, as there were no other treaties have been relied on by the United Kingdom as conventions or treaties since the declaration of the Iranian. Thus, International Court of Justice did not have any jurisdiction over the issue.
Hello everyone, my name is Izan Shafi and I will continue talking about the ratio of this case. So the most favoured nation condition in the 1857 Treaty of Peace between Iran and Great Britain was not typical of a capitulatory system such as that existed which in Persia at the time. Similar standards are established in Article 2 of the 1903 Commercial Convention between the two nations. In 1928, when Persia began to face down extraterritorial rights for foreigners, a letter exchanged on May 10th between the British minister in Persia and the Persian acting foreign minister agreed to uphold Article 9 of the 1857 treaty. Iran then made full use of its freedom of action by submitting a statement that was limited in scope and bolstered by 3 specific exclusions and a reservation. This gives more weight to the Iranian declaration's limited components that it is necessary. Next, the court lacks jurisdiction unless and until a state accepts a jurisdiction by a specific agreement, treaty, or convention. The court does not have the authority to read a statement more broadly or more narrowly than the state has decided. The most favoured nation provision in the British-Persian treaties were only promises of non-discrimination, so they were legally enforceable. There existed a transitory right to announce anything, but it has nothing to cling to unless and until another nation's citizens got favours. So moving on to the Obiter Dicta. According to President McNair, no state was compelled to recognize the court's jurisdiction under the United Nations Covenant or the Permanent Court of International Justice Statute. And Article 36, Paragraph 2 did create a method for states to do so voluntarily. A state may limit the scope of its declaration in any way it chooses, subject to reciprocity. The absence of a reasonable doubt abrogating its jurisdiction does not need to be considered if, as in this case, this intention may be persuasively shown to the court. And the court's fundamental problems is whether the following sentences in the Iranian Declaration of Acceptance of the court's jurisdiction are interpreted correctly. There is actual doubt in the text, and it is both acceptable and necessary to go beyond it to see whether the context sheds any light. Iran's choice to restrict its acceptance to conditions and facts, directly or indirectly linked to treaties or conventions, was unique, and one is obligated to inquire as to the logic for this unusually restrictive approach. Last but not least, the dissent of this case was stated by Judge Alvarez, where he said that lengthy arguments had occurred in both written and oral sessions of the present case before the court. In his opinion, all legal questions about the jurisdiction of the case have not been sufficiently resolved. He will address the difficulties from a legal position before applying the law to the facts of this case. The Iranian Declaration of Adherence should not be construed in the same manner as unilateral agreements, conventions, and legal instruments have been interpreted in the past, but rather in light of modern international reality. It lays the groundwork for a treaty to be signed by Iran with the states that had previously agreed to the terms of Article 36, Paragraph 2 of the Statute of the Court.
There are some arguments made by the plaintiff in this case. The plaintiff in this case is the government of United Kingdom. The court's jurisdiction is the sole subject. Whether or not it might be addressed by prior objection. The court has jurisdiction over any cases covered by Iran's statement recognizing the optional clause according to Article 36, Para 2 of its statute. That as a result of the third finding, the court has jurisdiction to hear the United Kingdom's allegation that Iran breached the duties to the United Kingdom by enacting the law of 1st May 1951 related to the nationalization of the Iranian oil sector. They claim in paragraph 3 of the Iranian findings that the Persian declaration adopting the optional clause only applies to disputes resulting from treaties ratified by Iran after the date of ratification of such declaration is incorrect. Contradictory to the fifth summary, The Persian Proclamation is restricted to the conventions and treaties accepted by Iran after the date of approval of its own declaration willing to accept the optional clause. The court has the authority to hear the United Kingdom's allegation that Iran has breached its duties to the United Kingdom as a result of the treaties or conventions acknowledged by Iran. The United Kingdom has neglected the accusation developed in message of its definitive conclusion enclosed in paragraph 48 of the United Kingdom Memorial of October 1951. Furthermore, the current dispute between the United Kingdom and Iran does not concern a topic that, according to international law, is solely within the jurisdiction of Iran, and hence the court's jurisdiction is unaffected by the Iranian statement recognizing the optional clause para 7 of Article 2 of the United Nations Charter is irrelevant to the court's jurisdiction. Article 2 of the United Nations Charter is crucial to the court's power. The current matter is not primarily within Iran's domestic jurisdiction. Finally, the decision for several questions will be concluded and submitted to the court, which are not counter-arguments to the court's jurisdiction and could only be made the decision if the court had jurisdiction. The Iranian government had conferred jurisdiction on the court on the basis of the forum prorogatum principle. Additionally, there are some arguments made by the defendant in this case. The defendant in this case is the government of Iran. According to the appeal, the Iranian government should be forced to provide full satisfaction and indemnification for any acts undertaken in relation to the Anglo-Iranian company that were contrary to international law or the Concession Convention of April 29, 1933. The manner in which this satisfaction and reparation were to be provided should be determined in the same way that the United Kingdom government requested in its memorial as its main demand for restitution of the enterprise to the concessionary company and determination of the damages due to the said company for loss and damage. As the second alternative, the section of the Nationalization Act relating to compensation should be ruled inadequate under international law, and the amount of such compensation should be established through arbitration or by the court. As a result, the first two claims are inadmissible since the government of the United Kingdom, in its declaration of August 3, 1951, abandoned its request for adjudication of the claims, and the third claim is inadmissible. There was no such request in the application initiating proceedings, so the court has no jurisdiction to deal with it because this claim was formulated after the Iranian government's denunciation of its declaration of adherence to the optional clause under Article 36 of the court statute on July 10, 1951, and was not concerned with the resolution of a dispute. Further, the court declared that it lacks ex officio authority under Article 2, Paragraph 7 of the United Nations Charter. The United Kingdom government's claims are based on treaties negotiated between Iran and other powers, or on benefits that may only be claimed by the United Kingdom through the use of the most favoured country clause, along with an alleged implicit agreement between two governments in correlation with the restoration of the Anglo-Iranian oil company's tender in 1933, which tacit government agreement is expressly disputed and in any case lacks the identity of a treaty or convention because it was not concluded between states, was not put in writing, and was not registered in accordance with Article 18 of the League of Nations Covenant, which was applicable at the time. Disputes arise between these two parties, which are Iran and United Kingdom, can be considered as a big issue globally. International relations are intimately related to disputes. These conflicts are increasingly being fought not only between states but also between states and other parties such as international organizations and other non-state players, as well as among these actors themselves. In this context, the United Nations Charter plays an important role, particularly in conflicts between nations, because the United Nations Charter does not specify how or by what means conflicts must be resolved. The parties are free to pick their international dispute settlement process. Therefore, by following the right track of a procedure, the disputes between these two states have been resolved, which is by following the court's.
So Article 33 of the United Nations Charter gives a range of options for resolving conflicts, including dialogue, inquiry, mediation, conciliation, arbitration, and judicial resolution. Because decision that the declaration applies only to treaties and conventions that Iran ratifies after it is approved. Other states are free to accept a document deposited with an international organ on its face value, such as a declaration accepting the court's compulsory jurisdiction. They are not required to refer that state's municipal law for clarifications on the instrument's meaning or significance. In many circumstances, such a tactic will destabilize the whole situation.
There are two essential elements of a treaty in which firstly, the agreement must be between subjects of international law and secondly, it is governed by international law. The treaty itself is defined as the international agreement that must be between countries and not between the individuals and the country. The agreement between Anglo, Iranian Oil Company Limited and the government of Iran cannot be viewed as a treaty because the Anglo-Iranian Oil Company Limited was considered as individuals. In addition, the parties involved in this case was between the company and the country, in which between the Anglo-Iranian Oil Company Limited with Iran, and it was not between the countries, and therefore the court did not have jurisdiction over the disputes. International Court of Justice has no jurisdiction over the agreement between the Anglo-Iranian Oil Company and the government of Iran, as in Article 38, Clause 1, Clause A of ICJ, statute has stated of the court can decide with international law if there is a dispute, such as international conventions. In conclusion, the case of treaties must be taken care precisely, in which the small matters such as grammatical error need to be investigated, as the court does not have any jurisdiction over such matter. Each government needs to evaluate the concerns in respect to the parties, which is international law, and the matter that is in the present based on the modern international law. In addition, both government needs to discover both treaties in which if there is a case similar like the issue, and it will not affect the governments.